Be ready. Start. The second consideration which may be referred to is that in subsection 4 of section 74 of the Excise Act, though it is provided that for the purposes of section 190 of the Criminal Procedure Code, the report submitted by the excise officer shall be deemed to be a police report. Section 190 of the code as it stands at present no longer uses the term police report, but the term was altered in 1923 into report in writing of such facts made by any police officer. In the Excise Act, the wording was not amended at the same time, and the old wording which occurred in section 190(1) clause B of the code before the amendment of 1923 still persists. Since section 190 of the code does not now contain the term police report, that term as used in subsection 4 of section 74 of the Excise Act can no longer be taken to mean a police report in the technical sense as interpreted in Premchand Khatri's case, but can only be regarded as equivalent to a report in writing of the facts made by any police officer as used in amended section 190(1) clause B of the code. Thirdly, even if we were to concede the argument of Mr. Dutt that the term police report as used in subsection 4 of section 74 must be taken in the technical sense as interpreted in Premchand Khatri's case, the fact that an excise officer submits such a police report for the purposes of taking cognizance by a magistrate does not import all the provisions of section 173. The report of the police officer is referred to in section 173(1) of the code. Subsection 4 of section 173 of the code provides that after forwarding such report, the officer in charge has the duty of furnishing copies of the necessary documents to the accused. If the term police report as used in subsection 4 of section 74 in the Excise Act is taken in the technical sense, then we may say that a report submitted by an excise officer corresponds to a report submitted by an officer in charge of a police station under section 173(1) of the code, but there is nothing in section 74 of the Excise Act from which it may be held that the provisions of subsection 4 of section 173 are also attracted. As already stated, section 74 of the Excise Act does not make section 173 of the code applicable to proceedings and investigations under the Excise Act. Without a mistake can only have meaning if both the respondent and the appellant were present there. Otherwise, it will have to be assumed that Shri Ajit Singh, Ben's advocate for the appellant and the judge presiding over the executing court, all three either conspired into preparing this record falsely in the absence of the respondent, or at least the presiding officer of the executing court was so negligent that he did not notice such a conspiratorial agreement between the counsel for the parties. There is absolutely nothing in support of any such fantastic suggestion, and no suggestion has really been made. That being so, the proceedings of July 6, 1960 in the first execution application prove beyond question that within 12 to 15 days of the date of the decree for restitution of conjugal rights, the appellant was obliged against to seek he assistance of the court in the shape of an endeavor to put up the decree into a execution against the respondent. And within the next about 2.5 months, the respondent appeared in court and against agreed to go with the appellant and obviously live with him as wife. That was the reason why the first execution application of the appellant was dismissed. The miscellaneous application on behalf of the appellant signed by his advocate Shri Brahmanand dated July 6, 1960 and has already been pointed out has not been written in clear language to say what was intended to be conveyed. However, it appears to be an application on the side of the appellant in reply to some application made by the respondent, but no such application by the respondent is available on the file of the execution application. Here is no endorsement by official of the court on this application, but as already pointed out, there is a mark of the court seal at the back of it. This application has been taken by the learned single judge to be not a genuine application, and suspecting that it may have been introduced in the file at a later stage, otherwise it would have had the endorsement of some official of the court, the learned judge came to the conclusion that it was an attempt on the part of the appellant to create evidence in his favor on July 6, 1960, that the respondent was refraining to live tuition of conjugal rights against her. Unfortunately, so it appears the original file of the first execution application was not before the learned single judge, and he had not therefore the opportunity to see the proceedings of that court on that day, proceedings made up of the statements of the counsel for the parties and the orders of the executing court.